Hello. I want to share with you an interesting court case involving drones going on right now. This is David versus Goliath, as Michigan Coalition of Drone Operators, a relatively tiny organization, filed a complaint against the University of Michigan. This stems from an interaction between a University Department of Safety and Security officer and a Part 107 drone operator. The officer reportedly told the operator she was in violation of university policy because the aircraft she was operating was over university property, even though the place from which she launched, landed, and controlled the drone from was not on university property. The officer did not issue a citation, but forced her to pack up and move along, and handed her this card, which reads, "It is unlawful to operate a drone on or over U of M property. Violations of the ordinance can result in a civil infraction, misdemeanor, fine, and/or impoundment of the drone." This is interesting, to say the least, as the state of Michigan has a strong drone preemption statute, which prohibits any political subdivision from enacting or enforcing any regulation that pertains to the ownership or operation of unmanned aircraft. Furthermore, the FAA controls the navigable airspace and prohibits any state or local government from creating rules that govern airspace. U of M's drone ordinance appears to be violating both state and federal law. So here are the highlights of the arguments being made in the court case. In the original complaint, MCDO argues that U of M is a public corporation pursuant to the Michigan Constitution and a political subdivision of Michigan pursuant to MCL 259.303 subsection D. An actual controversy exists between the parties. By this action, plaintiffs seek a declaratory judgment and injunctive relief. U of M ordinances state that, except as provided in section 5 and 6 of this article, it shall be unlawful for anyone to operate, take off, or land a UAV from, on, or over University of Michigan property, punishable by imprisonment for not less than 10 days and no more than 60 days, or by a fine of not more than $50, or both. So essentially, if you're convicted of violating this statute, the minimum jail sentence for you is 10 days. Michigan's Unmanned Aircraft Systems Act provides that, except as expressly authorized by statute, a political subdivision shall not enact or enforce an ordinance or resolution that regulates the ownership or operation of unmanned aircraft, or otherwise engage in the regulation of the ownership or operation of unmanned aircraft. As defined under the Act, U of M is a political subdivision of the state of Michigan. Further, the Act states, a person that is authorized by the FAA to operate unmanned aircraft for commercial purposes may operate an unmanned aircraft system in the state if that unmanned aircraft system is operated in a manner consistent with federal law. And then MCL 259.313 essentially says the exact same thing, except you can fly a drone for recreational purposes rather than commercial purposes. Federal law. The United States government has exclusive sovereignty of airspace of the United States. And there's a citation, which is found in 49 U.S.C. A citizen of the United States has a public right of transit through the navigable airspace, and the Federal Aviation Administration is charged with prescribing air traffic regulations on the flight of aircraft for navigating, protecting, and identifying aircraft, protecting individuals and property on the ground, and using the navigable airspace efficiently. U of M's regulations of UAS operation upon University of Michigan property is preempted by state law. U of M's regulation of UAV flight over University of Michigan property is preempted by federal law. Article 16, Section 6 of the U of M ordinances that requires a waiver to operate a UAS on or over U of M property violates state law MCL 259.305, MCL 259.311, and MCL 259.313, and federal law 49 USC, and it goes on to the rest of the citation. It's a lot of numbers and letters. Murphy, who is the drone operator in question, and other members of MCDO occasionally operate UAS and desire to do so for lawful, recreational, and commercial purposes within the geographical limits of properties under the control of the University of Michigan. Murphy and other members of MCDO announced plans to conduct a fly-in near and over the Ann Arbor campus of the University of Michigan on December 22nd. On December 19th, the interim chief of the University of Michigan's Division of Public Safety and Security wrote to Murphy referencing the fly-in and threatening to, quote, make contact with any UAS pilot and take enforcement action, end quote, for UAV overflight of the Ann Arbor campus during the fly-in. Here's a copy of the letter. Back to the complaint. Murphy and other MCDO members presently refrain from operating UAS upon and over the geographical limits of properties under the control of U of M solely because of the threat of imprisonment, civil fines, and costs of prosecution as specified within Article 16 of U of M ordinances. MCDO is not seeking monetary damages, only asking the court to rule that the U of M ordinance is invalid and prohibit the university from enforcing this unlawful ordinance. And here are the highlights of University of Michigan's response to the complaint. Plaintiffs, MCDO, complaint should be dismissed because they have not raised an actual controversy ripe for adjudication, and plaintiffs cannot satisfy their burden for declaratory and injunctive relief because U of M's drone ordinance is a valid exercise of U of M's powers under Article 8, Section 5 of the Michigan Constitution and not preempted by state or federal law. It goes on to say they agree that they sent the letter threatening the enforcement action. In a letter dated December 19th, 2023, UMPD Interim Police Chief Crystal James informed plaintiffs of U of M's drone ordinance and waiver process and that violation of the ordinance may result in appropriate enforcement action. Defendants never availed themselves of the waiver process about which they were informed by Chief James, but instead filed this lawsuit, making a facial challenge of the validity of U of M's drone ordinance in the form of declaratory judgment action. And then U of M spends several paragraphs arguing the case should be dismissed due to various reasons such as lack of standing, ripeness, lack of actual controversy, and the doctrine of exhaustion, claiming essentially that MCDO members would be required to first apply for and be denied a waiver from U of M before seeking court adjudication. Plaintiffs argue that U of M's drone ordinance is expressly preempted by the Unmanned Aircraft Systems Act, which is MCL 259.305. Fatal to that argument is that University of Michigan is not a political subdivision under the Act, which is defined as a county, city, village, township, or other political subdivision, public corporation, authority, or district in this state. The Board of Regents of the University of Michigan has a unique legal character as a constitutional corporation possessing broad institutional powers, and the Michigan Constitution provides, in relevant part, the Regents of the University of Michigan and their successors in office shall constitute a body corporate known as the Regents of the University of Michigan. The Regents shall have general supervision of its institution and the control and direction of all expenditures from institutional funds. I wish I could read this next part in the voice of Thurston Howell III, but they go on to argue that it has also been recognized that the board is the highest form of juristic person known to the law, a constitutional corporation of independent authority, which within the scope of its functions is coordinate with and equal to that of the legislature. A state statute preempts regulation by an inferior government when the local regulation directly conflicts with the statute or when the statute completely occupies the regulatory field. U of M is not an inferior government. Rather, it has a unique legal character as a constitutional corporation possessing broad institutional powers. The FAA oversees all aviation matters, including drones, but does not expressly preempt concurrent legislation at the state and local level. Any non-federal legislation, however, must comply with FAA regulations and may not relate to the prices, routes, or services of commercial air carrier. The complaint goes on to point at a Texas UAS case where the court found that the Texas drone law does not violate the First Amendment and therefore the FAA does not occupy the entire field of UAS regulation. Then, to prove that University of Michigan can regulate airspace, they link to an FAA fact sheet right here that includes, quote, states and local governments may not regulate in the fields of aviation safety or airspace efficiency, but generally may regulate outside those fields, end quote. And their complaint goes on to say that allowing drone operations / surveillance of education facilities could increase the risk of privacy breaches or malicious attacks to which college campuses, students, and university administrations are already vulnerable. Think of the children. For the reasons stated and argued herein, defendants respectfully request that this court dismiss plaintiff's complaint in its entirety, together with an award of costs and fees, and any other such relief agreeable to equity and good conscience. Alright, so this is already a long video, and I'm going to end it here. But the next brief in this series is awesome. It's a real piece of art, and I plan to make an entire video covering it in detail. Thanks for watching. Bye-bye.